Yeah, hi everyone. Welcome to another exciting episode of Brighty Podcast. If everything goes in line, this episode should actually drop on Christmas Day. Uh, Isaac is already in that group already. I can see the background
Yeah.
effect, the bling bling, the fireplace,
Mhm.
for our Christmas behind. How is Christmas
Yeah.
going for you, Isaac? Like,
Yeah, Christmas is going fine when the Christmas spirit and have a background here. So that's my virtual Christmas tree and my virtual Christmas decoration. So Merry Christmas, everyone.
yeah, yeah. For me, right? I've been well. I'm not on break, but I've been creating more time for myself to rest. Work is still going here. I'm not sure like take break. Maybe once in a
No,
while
we
they go on
don't.
vacation, but problem don't sleep. That's why we decided not to like take break from recording. Just to also you know put more content out there and you know be more accessible to the listeners. So even in this spirit of Christmas, you can take 30 minutes, few minutes to listen to our recording and yeah. So let's go into it, right? Um, we'll be talking about something. Is basically more or less like a continuation of what we had last week, but this time is all about what goes on in court. I know so many people general knowledge is that the court is an open space for everybody to come and sit down and hear proceedings. But the fun fact is that a lot of people have not even been to court before. I think for myself, if not that I'm a lawyer, it's likely that I would have never been to court too. So we'll try and just play out what goes on in court, what is expected, the backstory, and things like that. So I have Isaac here to just break things down for us, right? So my first question is this, right? I think for any regular person, right, you would like to know what actually happens from the first day in court until final judgment. Like you can just, run us through like a breakdown, a short breakdown of how it goes, especially in criminal procedure. Yeah, for civil, it's slightly different, but how does criminal procedure like go on take place in court? Yeah, take it away.
Yeah. So for the purpose of this episode, we'll probably just discuss criminal procedure alone because civil procedure has its own very specific areas and nuances and factors like that. Although they are similar, but they are very, very different. The rules that apply with civil does not apply with criminal. And if you remember, if you watch our last episode on this, we said that there are two types of bail. We have the police bail and we have the bail granted by the court. And at the point of arraignment, sorry, at the point of arraignment where a suspect is taken to court to be charged for the offense in which they are bringing against him, that is also where bail will be applied for. You will no longer apply for bail at the station or at the office of the security agency that arrested him if they decide to take him to court. So the power to grant him bail will be in the hands of the court. So the court will give their conditions. Okay, bring two shorties, bring shorties must have this, they must have that, they must things like that. So arraignment is the first step. And what does arraignment entail? Arraignment entail bringing the suspect into the dock. There's a place, I mean, if you've been to a courtroom before, you know that there are sitting arrangements. The judge sits in front of everybody, usually in front of like a high table or a high pedestal. Then to the left, although the sitting arrangement may differ from court to court, the dock could be sometimes to the left or to the right, or the witness box will be at the left side and the dock will be at the right side. Some courts, in fact, put their dock behind at the back at the extreme end. So the dock is where the suspect will step into And once he steps into the dock, they will ask him, what language do you understand? Is it English or is it Yoruba? Or if wherever the part of the country they are, if it's in the north, they may ask you, what language do you understand? Is it Hausa? Is it Kanuri? Is it this? Is it that? Or is it English? Which language would you prefer to hear these charges brought against you? And whatever language the person prefers, even if the person is here in maybe or your state and he says, oh, I only understand Hausa, they will get an Hausa interpreter for him to interpret the charge against him. If the person said, "Oh, I only understand Igbo," they will get an Igbo interpreter for him. In fact, I was in court one day and a woman said she only understands Pidgin, not even English, Pidgin. They had to interpret into Pidgin for her. It's part of her rights as a defendant who is arraigned for an offense. So what will happen is they will read the charge. Depending on the crime they are bringing against the person, they will read the charge. They'll say that you on so day went to do this, committed this offense against which is contrary to this particular law. What is your how do you plead? Are you guilty or not guilty? Now, depending on the person, depending on maybe discussions you've had with your lawyer, some people elect to say that they are guilty, some people elect to say that they are not guilty, some people elect to say, oh, I'm not guilty by virtue of insanity and things like that. So it's either you say you're guilty or you're not guilty, and then the trial would start. In the instances where a defendant will say, hey, I'm guilty, the prosecution would be required to um, present their facts before the court. Okay, he was arrested on so day doing this. He was caught doing with this and this and this. He wrote in his confessional statement that he did this, and this. And do they have witnesses? Perhaps they'll call those witnesses as well. And once that is done, they will now ask him, do you confirm all that this person is saying as true? Since you already said you are guilty, do you confirm it as true? And he will say, yes, it is true. And then the judge or the magistrate, in whatever case may be, would give a bench ruling. Sometimes they will give a bench ruling. Sometimes they may adjourn to give a bench, but most times they will just, since the prosecution has already given their evidence and the person is not objecting to it, they will give their bench ruling and convict that person and sentencing in some instances, or adjourn for sentencing with whatever the case may be. Now, when someone says they are not guilty, an entirely different path is created. So the person who says I am not guilty, now the prosecution would not just list out their facts and why they think that the person is guilty and whatever. They have to now prove that allegation beyond reasonable doubt. There is a standard for proving, for getting a conviction in criminal matters. If a suspect is arraigned before the court, if he's brought before the court for an offense and he says he is not guilty of the allegation of the offense, the prosecution who brought him have to prove that he did what they said he did beyond reasonable doubt. So if they fail in proving beyond reasonable doubt, he is going to walk away discharged and acquitted. So that is the way criminal trials go. That is the standard for criminal trials, beyond reasonable doubt. So we are saying a person went to rob a so place, a so time, and he stole so objects. You have to prove that he was there. You have to prove that he was the one who went to steal it. You have to prove that he indeed stole those things. And how do you do that? Perhaps maybe an eyewitness saw him. Perhaps maybe CCTV camera caught him. Perhaps maybe you found the objects that were allegedly stolen in his custody. Perhaps you traced it there or whatever. Perhaps you even caught him with those objects. So these are the things they have to prove. These are the pieces of evidence that they have to prove before the court. Say, okay, if you think about it reasonably, there is no other explanation for this offense. This person definitely committed it. But when then the prosecution proves their case and they are done proving their case, the burden shift to the defendant, where he has to now also defend himself against the prosecution. So is either then there are options for the defendant, or so the defendant in this case. Once they are in, they're no longer suspects, they're now defendants. There are options to defendant. He can either um, um, file a no case submission, rely on the case of the prosecution, or enter his defense. And when you file a no case submission, that's to say that, hey, all these things that the prosecution has brought before the court, they are not enough. They are not enough to convict me on itself, because they don't have a substantial case against me. So there's no even need for me to even say I'm defending myself. Their case is not worth me bringing my own defense and saying, "Oh, I didn't do this. This is my own piece of evidence." I think this is similar to what Navikanu did in the early part of his trial after the prosecution was done. And when the no case submission is done, it can either be upheld by the court or overruled. In Namdi's case, it was overruled. If the court says that, okay, it's true what you are saying, these people don't actually have a substantial case against you, you don't need to enter your defense, be going. That's one. If the court looks at it and say, okay, these people made quite a strong case against you, it's a hint, I think you should enter your defense. And they overrules it, next thing you do is enter your defense, typically. Or you rely on the case of the prosecution, which means that everything the prosecution says, I put reliance on it. I don't have anything to say. You're not even saying that they didn't even bring a case against you. You are saying that judge this matter based on what they have said. I don't need to say anything in my defense. So that's another option, which is a more dangerous option. Because once that is done, there is no chance for you to come back to enter your defense. There's no chance for you to, argue it out and whatever. And the third option is entering your defense, which means you have to bring certain facts and evidences before the court to refute and to poke holes into that the prosecution's case. Basically, all this is I'm saying is the job of your lawyer to do, but we are just trying to educate you as to how these processes work. Because for a long time, the process in which matters are determined in court seems like an enigma to most people that are not lawyers or into legal profession. And the purpose of this podcast is kind of just break it down so that you will not think that, oh, this is what this person said. It's obvious the judge is corrupt. That is not usually the case. It's just this is how the processes work. You have to prove your case. If they've proved your case, if they prove their case, you have to poke holes in their case to show that their case has no substance. You have to. So it's a war of arguments, a war of evidence, it's a war of proof. So if you do not do these things very well, you may end up being convicted and whatnot. So that is just part of. This is the purpose of this podcast, and I hope that we are getting across to you. So once defense is entered, and perhaps like I said, the example I gave earlier, perhaps the person who, let's say, he was accused of stealing, he said he broke into a shop, he carried some things away, and what have you. Maybe some people saw him, or CCTV camera saw him, or whatever. So again, let's say, for example, I want to defend this matter. They said he stole something. Let's say they said he stole it around 9 p.m. Okay. And their witness said they stole it around 9 p.m. I can cross-examine that witness and say, okay, you said you stole it around 9 p.m. Was there light during that period in which you said he stole these objects? Person may say, oh no, there was no light. So you can't see in the dark. That place does not have all these security lights around. Okay, it does not have. So you cannot say for sure that it was this person. You can say, oh, I don't necessarily think so. That's part of the defense trying to poke holes in the case of the prosecution. Part of defense that people rely on in criminal trials, alibi is one of them. An alibi means that an alibi is someone or any fact that can place you in another place as at the time of the commission of the offense. No person can be in two places at once. So if the prosecution is saying that you were here at a particular time committing this offense, and you can prove that you were not there, that you were in another place entirely doing something else, then that destroys the entire case. That's alibi. That's one. Another defense is insanity. Some people do not. Some people are mentally unstable or insane, and they do not have control of their mental capability. And in the process of not having control of mental capability, they committed a crime, or they killed someone, or they assaulted someone. They will not be held to be liable. You see all these madmen on the streets, if God forbid they kill someone, they are not likely to be sent to prison or to be convicted. Sorry, they may be held in prison custody, but they are not likely to be convicted for murder, in the sense that they do not have the capacity, the mental capacity to do it. And another thing is, in the criminal procedure, in criminal law, you require your mental capacity and the physical act. You have to have first thought of the offense, then carry it out. So if someone who is not even capable of thinking rationally, of having full awareness of the things that he's doing, of having the idea that what I'm about to do is bad or has consequences, if someone like that is not okay upstairs, that he can rationally make decisions, then he cannot held to be liable. It's a defense. Insanity is a defense, but you also have to prove insanity as that defense. All right.
Let me pick my next question from the point you raised earlier on, and it's from the point of whether guilty or not guilty. I think for a lot of people, they would raise the fact that why is asking somebody whether it's guilty or not, why is he of utmost importance, especially when the person obviously committed, this offense. What do you have to say about that? You know,
Well, what makes it obvious that they committed the offense? People like to say, "Oh, this person obviously committed the offense," but basically, they were not there. They were not there when the offense was committed. They don't know what happened. They only know the what the media tells them. I remember when this guy that they accused of killing a girl, one of his female friends, and then burying her at the backyard, and then a lot of other things. And they were like, "Oh, he's guilty. Why do they even need to go to court again? Why do they even need to go through all this process? Why are they wasting time?" Before they know it now, they will say court to maybe tell him to go, or they will convict him, then they will appeal it again. Why are lawyers like this? Or they will even cost the lawyers that are even defending him. And I'll be like, the judicial, this process isn't for the guilty people. It's actually for the innocent. We go through all this stress, we go through all this process so that we do not mistakenly convict an innocent person. We can rely on gut feeling all we want. We can rely on, oh, it's so obvious, but nothing is really that obvious, because if we are relying on, oh, it's so obvious, we will convict based on looks, maybe based on the hardness of some people's eyes. They are hard and they look like thugs, but just because someone looks like something doesn't mean they did what they said they did. I mean, if you are using that to if you're using that to judge someone and be like, hey, this person, oh, it looks like someone that must have done it. There's that feeling that you get when you look at someone, this guy did it, this guy definitely did it. There's that feeling, there's that idea. But sometimes it's not true. You were not there, you didn't see what happened, you didn't see how it went down. You just, based on the gut feeling, or based on the way we discriminate, and we how do you do, just classify some kind of people based on their looks and their perception. So we just that's how most people see things, even online or social media, and they just feel, oh, this person definitely did whatever they said they did. But it's important, because if you use that basis to convict people, you would actually sentence a lot of people, innocent people, to jail or to prison. And it's not right. It's really, really not right. There's nothing worse than going to prison or being punished for something that you did not do. It's a different level of pain for that. So we try to our process. The process is not perfect, right? Sometimes the guilty get away. That's a fact, but it's so that we would not by mistake sentence an innocent person to prison. In fact, the our criminal jurisprudence believes that it is better that 10 guilty people walk away scot free than for one innocent person to be sentenced and convicted for a crime he did not commit. Like that is, we see the life of one innocent person is worth the freedom of 10 guilty people. So if by any chance, any stroke of luck, any chance that we might convict an innocent person, we do not want to take it. So that's why we go through all this. Even if he was guilty, even if he was caught with a human skull in his hand, he has to go through that process. You have to prove that yes, by the fact that he had this skull with him, it means that he is a killer. It means that he is a ritualist. It means that he was the one that dug them, that did whatever they said he did. You must prove it, because if you are passing the sidelines and we are saying, oh, he was caught with it, there's no need, sentence him immediately, there will come a time when someone who is innocent is caught at the wrong place at the wrong time, and they will also be treated with that same method. And next thing you know, it innocent people are going down for what they have no business with. So that is why we even bother. Are you guilty or not guilty? Do you want to fight this or do you not want to fight this? And I think again, if we have to train our prosecution itself to reach a certain standard where they don't just bring cases to court for the sake of bringing them to court, where they bring them to court for the sake of having convictions. When you have the evidence, a lot of the time the prosecution may not even have the evidence against this person. They may just have maybe one person that will just come. I've been in the matter before when my former office handled. These guys were accused of stealing phones from people at gunpoint, armed robbery, and what have you. They said they went to steal phones with Okada and everything. I think they were bike men, and they were in prison. They arrested them, they arraigned them, and everything, and brought them to court. The only person that came to give evidence against them was the exhibit keeper. And they said that when he brought them to the exhibit keeper, is someone who keeps maybe the weapons that they recover from people, or the evidence of maybe these things they stole, or maybe part of the bodies that some people slaughtered or whatever. So he keeps them for it to be used in court. So they brought the exhibit keeper. Exhibit keeper, were you there? No. How did you know these people? The officer that arrested them brought them to me. He said that this is gun that they recovered from them, and they put them. Where is the arresting officer? I don't know. He's not here. Okay. Prosecution, they didn't bring the arresting officer to come and give evidence that, hey, we arrested these people at so place at so time based on this report. Okay, arresting officer, they not come. What about the victims that they stole the phones from? Where are they? They can identify them, can they? The victims did not come, they did not show up in court. They did not give evidence that I is this person that came to me, pointed the gun at me, and said that, hey, give me your phone. They didn't come. So the only person that came was the executive part to give evidence. And that one too, there's nothing he can do to prove that these people did it. So sometimes it's the prosecution that is like a daisical. And at the end of the day, whether or not these people did it, we don't know, because at the end, the judge is an impartial someone. He doesn't know anybody from anywhere. It's like you just being a random stranger, and then two people come and they start telling different sides of their story. You can't side with anyone because you don't know anyone. So you have to listen for the facts and use your judgment to decide which one is fair and which one is likely to be heard. In this case, someone was accused of armed robbery. Nobody came to prove that he actually committed the armed robbery. Nobody came to show the people he robbed this thing from. They didn't even show the objects they allegedly stole, like the phones they said they stole. So they just wasted their lives, 2 years of their lives in Nigerian Correctional Center before the judge said, finally gave a judgment and said, well, if people didn't even prove your case, so I have no choice but to let these people go. And sometimes that's how even perhaps guilty people walk free, because the prosecution didn't do their job that they're supposed to do. They will not present the proper evidence or the witnesses to ensure that these people are convicted. So that's the problem sometimes with the justice system. It's not the judge, sometimes it's the prosecutor. Oftentimes it's the prosecutor. So we have to, these places and these processes are in place to protect the innocent.
All right. Yeah, I was going through Twitter lately. I don't know if you saw it, right? But there was a very funny tweet I saw.
Mm.
I think a law firm, I don't know how true it is, I guess it's banter. A law firm created an office of cross examination. Uh, it's strange, right? But it's not, it's possible. It's something that I don't think is out of the ordinary. Um, I guess that shows the very importance of cross examination. Uh, this one is going to be more like I want you to give like a real life scenario of you know, taking cross examination during a criminal proceeding. You can, cite different examples to make it a bit more exciting. You know, what is really like the importance of this, and what are some of the ones you've gone through that you find quite exciting, and yeah, how was the outcome of it?
All right. So cross exam. Let me start with defining what cross examination is for our audience. Cross examination basically is trying to, because for every witness that comes to court and they give evidence, they have to you have to ask them questions. So if the prosecution brings a witness and says you have to start asking questions in order to get that information out of them. They won't just come, stand there, and they start talking. And so what happened was that, and on so day I went to work, on work I went to get and I caught this person. No, the prosecution will have to lead him in evidence. Okay, what is your name? What's your address? What do you do for a living? I live here, I work here, this is my name. Okay. Do you know this person? Yes. How do you know this person? Oh, I know him because I arrested him on so day. Okay, can you put us through how that came to be? Then he will now start explaining. Oh, I was called, we received a signal to come and this thing. Someone was committing an armed robbery, and we went there and we saw these guys, we exchanged gunfire with them, and then we caught them, and that was that, and that was how we got them to the station, blah 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 blah. That. So the job of the defense lawyer or the lawyer to the defendant is to now ask questions that would refute or impeach the credibility of what that person just said. So I can ask, start by asking him, okay, you said you arrested this person for armed robbery, and you said you recovered so items from him. Okay, when you arrested this person for armed robbery, when you got to the scene, did you see any gun on him? That's one question. Depending on the scenario, if I and the rule about cross examination is don't ask a question you do not know the answer to, and don't ask open-ended questions. Let me not give all our tools of trade to you guys. So you do not ask leading questions, you do not ask open-ended questions that allow the witness to explain. You only ask leading questions. You only ask leading questions. So, hey, so I will be correct to say that on that day when you arrested Mr. B, you did not find a gun on him. That's one question. You can say, no, I did not find a gun on him. Okay. I've already laid, I've already done something there. Or, okay. And when you arrested Mr. B, you did not arrest him at the crime or at the scene of the crime. You can say, no, I did not arrest him at the scene of the crime. We went to look for him. Okay. That's another one. When you arrested Mr. B, I'll be correct to say you arrested him at his house, Abi. You say, yes, I arrested him at his house. Okay. When you arrested him at his house, these things that you said they said they stole at the supermarket, you did not find any of it at his house. And no, we did not find any of it at his house. That's fine. Now I've been able to take out some things from his testimony. I've been able to poke holes. This is just a scenario. It may not be as straightforward as this. I'm just trying to make a scenario. First of all, you didn't arrest him with a gun on his person. So that means he wasn't in illegal possession of a firearm. That's one offense that is already gone. Second, you did not arrest him at the crime scene. So the credibility of the fact that, oh, maybe he was even there is already shaky. It's already on a shaky premise. Then you went further to look for him at his house to arrest him. And when you got to his house, you broke into his house, but you didn't even find any of the things that they said was missing from the place that he robbed or any of that. You did not find it there. And you say, when we did not find it there. That's another one. So not only did you not see him with a gun, he was not even where you said they committed the offense, and any of the stuff that said it was stolen is not in his house. So would I not be correct to say that this person was not even there at all? He's not even connected to this crime at all. So it's kind of like that. That's how cross-examination works. It's to impede, and sometimes we use it to impeach the credibility of the person that is saying it, not necessarily just what they are saying, but who they are. And we can say that, although they don't necessarily use this in Nigeria, but you can try and catch them in a lie, or maybe even refer to a previous case they've done where they lied. If you try and catch them in a lie where they contradict themselves, maybe he had said something here, and then you now ask him a question and now say something there. We'll just use that at the final address and be like, this witness is not even a reliable witness. He is lying. He didn't know. He's saying this thing and he's saying another thing entirely. So two piece of evidence cannot coexist and he cannot be like. So that's kind of how examination works. And then you
All right. Yeah. Thank you very much for that. Right. So I'm going to we'll try and make the episode as short and concise as possible. But I will ask this last question, right? Which is also a question that lawyers too like to ask, and it's really about our criminal system. Uh, why are there so many adjournments? Why are there so many delays? Why are there so many objections? Um, what do you have to say about some of this issue? Because I think there's general saying that says justice delayed is justice denied. But it looks like in our own place, we have cases that have been pending for years, even criminal cases. I'm not even talking about civil matters now, like criminal cases that goes through different adjournment, different delays, different, you sorry that I'll bring this example in. Well, we could see how the Puff Daddy PDD case, was done. I don't think it went on for a year. I don't think so. I don't think it was up to a year. But the fact that it's even like a big celebrity over there, if it was Nigeria and somebody of that stature, let's believe that case is going for nothing less than a year at least. That case cannot be wrapped up in that period it was it was done. You understand? So I mean, people want to people want this case to be finalized and let's get it over with. So why do we spend so much time with criminal proceedings in court? Yeah, take it up.
Yeah, for the record, the earliest I have seen a criminal proceeding concluded in Nigeria is 2 years. Earliest I have seen, and 2 years, and the longest I have seen is 13 years.
That's serious.
13 years. It was during my externship. The man was arrested and charged for armed robbery, but he didn't even. They were not. I think the problem with delayed criminal trials or elongated trials like this is not necessarily how do I say it's not necessarily a conscious thing or something that was strategically in place, but because of a lot of other factors. like the low number of judges. Best believe it, we do actually have a lot of judges, like we should. The numbers in which we have, those ones are already overburdened enough as it is. One judge can have 3,000 cases in his docket, active cases in his docket, 3,000, and he has to meet a quota. Each quarter of the year, they have to meet certain number, they have to dispense a certain number of cases, judgments, and new ones are coming in every day. New ones are coming in every single day. So they have to dispense those number of cases, try same criminal and civil alike. There are not enough courts. If there are not enough judges, there are not enough courts. Judges are courts. So judges are not enough. And again, a lot of cases that shouldn't even go to court are in court, especially at the magistrate level. At the magistrate level or at the customary court level, the police officers are the ones that come to prosecute, not the lawyers. So some of their cases, they're not really legally trained. They just, almost any case, they will just pack you and take you to the magistrate court to arraign you there. If you are proving difficult, if you are not cooperating, they'll take you to court. And they waste your time there. Even if they may not win, oh, they may not win. They may not, they know that they will not win, but that they will not waste your time is a lie. And you may be there for 3 years. And because cases are too much and they are too much for the magistrate to handle or the judge to handle, so over time, and sometimes lawyers also are part of the reason why it takes so long. Part of the reason why it takes so long. They can ask for numerous adjournments, but I think now the ACJ, or like the Administration of Criminal Justice Law and Act of the various states and the FCT, try to limit number of adjournments that you get in criminal trials, or try to make criminal trials more expedient. Not necessarily limit number of adjournments, but try to make it expedient. So the judges are more inclined to, of course, be more how do I say it, more disciplined when it comes to criminal trials, or more strict. Like, don't waste this person's time. Criminal trials since 2018 and we're in 2025. What are you still doing? Do you want me to strike this thing out so that this person at least will be going, and when you are ready, you come and bring your proof and everything? So it's also it's a systemic problem in terms of resources, facilities, judges, and even lawyers. Sometimes a case can just be jumping from one court to another. Maybe this justice retired or is promoted to the court of appeal, then the case has to be transferred to another judge and he has to start all over again. So it's a lot of systemic issues, right? And if there's one thing I appreciate the federal prosecution of the United States for, is that they will not come after you until they have all their evidence. And it's scary the way they move. They have a 95% conviction rate. It's crazy. They will gather all the evidence they need to gather against you for years.
95%.
95% conviction
Where do
rate.
you get that's high.
Yeah, it is. It is. I think I read it somewhere. 95% conviction rate. They will go after you with everything they have. They will use their resources to chase you for years. I mean, even you look at the trial of someone like Young Thug. They didn't come after Young Thug until maybe like 2022 or so, or 2021, if I can remember correctly. Even a lot of all these other people, they would wait and gather their case against you, build their case step by step, step by step.
Even a lot of the internet fraudsters
Even a lot of these internet fraudsters. And funny enough, a lot of their convictions are not based on, they don't necessarily even go to trial. Once the person and his lawyer just sees the evidence against him, like, oh, Benny, maybe you should just take a plea deal and just go to jail, JJ. Because if we take this thing to trial, it's not likely you'll come out of it. So just take a plea deal. So most people just take a plea deal and be like, hey, and a plea deal is basically, okay, I will concede to the fact that yes, I am guilty of this thing that you are telling me to do, and maybe in exchange for that, reduce sentencing, or maybe I'll give you information for reduced sentencing or whatever. So sometimes that's one of the reasons why people plead guilty in court, and they already have a plea bargain. Over here, we call it plea bargain. and then for some reason, maybe especially when it comes to some of these internet fraudsters, they would they would maybe forfeit some of the money that they've already stolen, or they've scammed people off, and then they'll go. So that's that about that.
Well, thank you very, very much. I'm just checking my time, and I can see that yeah, we seem to have taken so much time on this episode, right? Exciting stuff. There's so much that we didn't talk about, sincerely. But I don't think there's any other way that can give you this kind of better breakdown than this. Isaac has walked us through how it goes from the start to the end. There are also even other issues like what goes on in appeal that we didn't even touch on, right? But yeah, that's not law is very expansive. There's so many to talk about. There are so many topics to go through and stuff. Yeah, you'll still be here next week. Like I said, we're not taking day off. Yeah. Like I said, trouble no they take rest. So that's just the thing. So yeah, see you again next time. Thanks for joining us again.